Welcome to another Friday edition of Life Experiences with William Pelarenos, and I am your host, William Pelarenos. And part of my life experience was I was a policeman for 27 years, and during that time I worked with some very good prosecutors, and I'm lucky to have one of those former prosecutors on the show today, Omer Jaleel. Welcome to the show, Omer.
Thanks, Bill. Wonderful to be here.
All right. Omar was my prosecutor at Daly Center when he was a prosecutor. You were a prosecutor from 2008 to 2012, right?
Yes.
Okay, so I was down at Daly Center from 2009 to 2012. And at Daly Center, we strictly did traffic cases, misdemeanors like reckless driving, DUIs, and of course, traffic violations such as disobeying red light, speeding. And Omar was prosecuting my misdemeanor, the DUIs. I remember went to trial a couple of times. He's an excellent prosecutor, but since 2012, you've been a private attorney, correct?
I have been, yeah.
And when you first went into private practice, you started defending criminal cases, immigration cases, and then your practice drifted into what you do now, strictly appeals, correct?
Correct. Appeals throughout the state of Illinois.
Yeah. So tell the audience exactly, if they don't understand appeals, where does it start? It starts from the person being convicted of either a criminal case, a traffic case, a felony or misdemeanor case, and of course a civil case, correct?
Correct. I mostly handle felony cases, so it starts from the time that somebody is convicted of an offense. They go to sentencing. Once sentencing is completed, they have a choice to take the case up to a higher court, which is the appellate court. And in the appellate court, there's 3 justices that will hear the case, and they will make a determination as to whether what happened in the trial court below was correct, was fair, whether due process was followed, and they can remand the case back for a new trial. They can reverse the conviction outright and enter a finding of not guilty, or they can affirm the sentence, which means that they didn't think that anything was incorrect. And that decision can then be appealed to the Illinois Supreme Court.
Now, you've been doing appeals since, what, 2018?
Longer than that. My entire career, I've been doing appeals, either as a defense attorney or as a prosecutor.
Well, as a prosecutor, I know you handled appeals for the Cook County State's Attorney's Office for several years, and now you do them strictly as a private attorney. But you're not only appealing for the defendant. In civil cases, you may be appealing for the plaintiff that lost, correct?
Correct, yeah. The plaintiff, anybody who loses a decision in the trial court has a right to appeal that decision to the appellate court. The only people that don't would be the prosecutors if they lose and there's a finding of not guilty.
Let's talk about, people don't understand when you're going, let's stick with felonies, okay?
Okay.
Say I'm charged with aggravated battery. I struck somebody and I caused great bodily harm. I go to trial. Either judge or jury, depending on how I picked the case should be heard, makes a decision. Before that decision comes down, I should be prepared, just in case I'm found guilty, to seek an appellate attorney like yourself, because there's only 30 days to file from the day of that conviction. Am I correct?
Correct. From the time that you're sentenced is generally when the time period starts ticking of that 30 days, and that's what's called a notice of appeal. It's the formal way of transferring jurisdiction of the case from the trial court to the appellate court. And the appellate court is in a completely different building, completely different justices. There's 5 of them throughout the state, so depending on where you're located, it'll go to one of the 5. The first district is in Chicago, second district is right here in Elgin, the third district is in Ottawa, 4th is in Springfield, and the 5th is all the way down south in Mount Vernon.
Very good, very good. So people got to understand that when you're rolling the dice and going to trial, you got to be prepared in case you lose. Because if it's a felony, you'll most likely be taken into custody. And from the jail, it's hard to be trying to hunt down for an appellate attorney. You know what I'm saying? It's just improbable.
Yeah, it's absolutely. You have to be prepared. And almost always in a felony case, you're going to be taken into custody once you're found guilty. And, so that could be 30 days before you are actually sentenced. And then, you'll stay there until they ship you off somewhere in the IDOC system.
Yeah, so it's important to get all your ducks in a row if you're facing this. Now, many of our listeners are not involved in this, so this is just nice to know information because, trust me, even as a policeman, I've known policemen that have been charged with felonies, excessive use of force, official misconduct, stuff like that. Anybody can fall into the legal system a moment of anger, and it happens. And I've seen it. I've seen it with policemen. I've seen it, of course, with defendants. I've seen it with neighbor disputes.
Yeah. A lot of guys we work with, unfortunately, got caught up in stuff that they shouldn't have been caught up with. So it happens,
Yes. So you know what? I forgot to mention at the beginning of the show. Our phone lines are open, Matthew.
Yes, 847-931-1410.
And they can catch us on YouTube at?
YouTube.com at WRMN Radio.
You say that very fast. A little slower.
YouTube.com at WRMN Radio.
Oh, he's the best. And they can text us on a line.
Yep, 505-926-1410.
So if you got any questions, we're trying to explain the appeals process to people. And not a lot of people fall into this, but if you're facing especially a felony, I noticed on your website, give me at your website, you'll bring it up on YouTube.
It's defenseadvocates.com.
Defenseadvocates.com. Okay. As we're scrolling down that website, you also have listed civil case appeals. So why don't we talk about civil cases for a minute that you've defended as a private attorney? Oh, appealed, not defended.
I've done a lot of family law-based appeals, child custody issues.
So with the
spousal
child
support.
custody, one parent has lost custody and they have the right to appeal that to the
Exactly.
appellate court, even though it's a civil case, correct?
Exactly. Everybody, any civil case, any case that's gone through a trial, you can appeal that case. The only types of cases that you wouldn't be able to appeal is in civil cases if it's a negotiated settlement, or in criminal cases if you plead guilty.
Very good, very good. A lot of people don't understand that once you take a negotiated settlement, that's it. It's done, correct?
Pretty much, yeah.
You're signing off on it. You're saying this is okay. But I've also seen negotiated settlements on personal injury lawsuits where I've had to testify as a policeman to the accident and what I saw, what I observed. And then before trial, they negotiate a settlement. There is no trial.
Yeah, exactly. That's almost always what happens in civil cases where there's just a negotiate. Even in criminal cases, a lot of cases are just
As
flat
they
out
get
done.
closer to that court date, people start panicking or decide to cut their losses and just take a settlement.
Yeah, and it goes both sides too. It's not just a defendant feeling scared of going to trial, but it's also the state. They sometimes have to put up the goods, and they may not have them, and they would rather settle a case by having a plea of guilty than taking a chance of losing it at trial.
Yes, and you've heard this term before. The state has said a lot of times when they've negotiated a plea or when they've just not gone, they said, we probably can't meet our burden of proof, correct?
Yeah, this is after the fact. This is where you've gone through the discovery process. The defense attorney sent out investigators, potentially expert witnesses have been retained, and everybody is set to go to trial. And on the day before trial or the day of trial, an offer is made by the state that wasn't made before that the client is willing to take, or a settlement offer is made by the defendant in a civil case that the plaintiff is now willing to take.
All right. Let's go with what you do. Let's use that same scenario I started at the beginning of the show. Let's say I've been charged with aggravated battery. I punched somebody, caused grave physical harm. I had a criminal defense attorney represent me. We lost the trial. So now I retain your services or an appellate lawyer who deals with this to represent me, and who files that within 30 days? Is that you as the appellate attorney, or is it my criminal attorney notifying the court within that 30 days that I'm going to appeal it?
It could be either. It also could be the judge telling the clerk of the court to file it on behalf of the defendant. The Supreme Court rules allow a circuit court clerk to file a notice of appeal on behalf of a defendant. It's just a very simple document to transfer jurisdiction over from the trial court.
And that's where your legwork has to begin, because now you have to draw up what's known as a brief, correct, to the appellate court?
Correct. The first thing that would happen before the brief is done is the appellate record needs to be prepared, and that consists of the trial transcripts, the court file, motions that were filed, orders by the court. And once that's prepared, the next step is really the crux of the case is filing that appellate brief. And the appellate brief is the Supreme Court has a whole bunch of rules that need to be followed on the format, the margins, the type of font, the color of the front page. And once you file that brief, the state then gets an opportunity to file a response. And then once they file a response, because the burden of proof is on the defendant who lost at trial, they get to file a reply to whatever the state filed or the appellee filed.
Now, in your brief, you just can't say, hey, we didn't like the decision. You have to drop some reasons, such as improper jury instructions. That's one that's been used, correct?
Yeah, improper jury instructions. The type of errors that occur at trial is really limited to the creativity of the attorney. There's, issues that the judge made. There's issues that the attorneys would have made. There's evidentiary rulings that are made. There's factual issues that are potentially evidence that was not allowed into evidence, or evidence that was allowed but shouldn't have been allowed. The type of issues on appeal are really limitless.
One of the issues that was raised, and I'm doing this from memory, many years ago, one of the cases that I read was somebody was charged with a felony. During the jury instructions, the judge failed to mention that the jury also had the opportunity to reduce the felony to a misdemeanor and convict him of a misdemeanor. And that was used for an appeal. Does that sound...
Yeah, I just had a case in the 3rd District that was, the conviction was reversed for that exact reason, where the client was charged with the felony domestic battery case, and the jury should have been also instructed about a misdemeanor, that they had an option to convict the client of a misdemeanor domestic battery, and the sentencing range was vastly different. The felony, he was facing between 4 and 15 years in prison on a felony charge. On the misdemeanor charge, he was facing a maximum of 364 days in jail.
Just in case our listeners don't understand, a felony is the most serious charge. It starts with 1 year and up, depending on the class of the felony. 1 year and up that the defendant, if convicted, faces in prison. Whereas misdemeanors is less than 1 year, 365 days or less. So it doesn't have to be 365. I've seen judges for revoked driver's licenses, they send people 5 days to Cook County Jail. So
and that's sorry.
Yeah, anything can that parameter of incarceration is up to the judge. So it could be anywhere in that 365 for misdemeanors.
And where you're sentenced as well, where you do that time is different. On a misdemeanor, it'll always be done at a county jail, whereas a prison, you'll go into the Illinois Department of Corrections and be sent to one of their prisons throughout the state.
And while the appeal's going on, obviously the defendant is sitting in prison. I know the system in Illinois has changed, but do they still allow like an appeal bond or to be out while waiting appeal, or not in Illinois?
It's rare, Bill.
It's rare?
Very rare. It happens, but I wouldn't plan on it occurring.
Yes, what you got to plan on if you're in this rabbit hole, you got to plan on seeking your second attorney. And you know where this comes to mind? If you remember the O.J. Simpson case in California, he not only had his lawyers, his defense attorney, his DNA experts, everything, but he also had an appellate lawyer watching this whole thing while it was going on, Dershowitz, ready to appeal it just in case they lost. I mean, he had all his ducks in a row, you know?
And when you have unlimited money, that's the best way to go about it.
But you know what? When you're facing a felony a year or more, if you're facing 14 years in prison, you might as well take out a loan, a reverse mortgage, because I'd rather be paying a reverse mortgage than be sitting in a 8x12 cell. So, and you know what? We don't condone criminal activity, but there's no doubt that a lot of people have been overcharged. I've seen that when I was a policeman, and I've read many cases. And speaking about cases, when you file your brief, which is your written document to the appellate court, you sometimes have to throw case laws from previous cases in there, correct?
You have to. Pretty much every line in your argument, there's different sections that you have to put into a brief. What we're talking about is the argument section, and pretty much every line you write in an argument section should be supported either by the record in the case or by case law.
So writing this brief, it's an incredible amount of research that goes on, because you have to find cases that are similar to your defendant's case and a ruling that you can base the argument on that you're trying to appeal this brief on, correct?
Correct. You know, I've cited cases from the 1800s before.
Really?
Yeah. There's reasons why you would want to do that potentially to show that this particular legal principle is so well established that it goes back to, pre-Civil War days. Or you may want to show that the original intent of what the law was different than how it's being applied today. So you may want to do a summary of how this law has changed over time. That's going on with cannabis laws, of how cannabis laws have changed. Pretty much every one of my briefs related to that deal with cannabis have a history of what the cannabis laws in the state have been from the time of prohibition till today, and how they've changed, and how the court system has adapted and changed how they define words in these various different statutes.
I'm glad you brought up cannabis, because people don't understand, and this is a big confusion. People should be still being arrested. I know this for a fact, because even though we have recreational cannabis that has been decriminalized, and there's many stores that sell it, cannabis dispensaries, you can buy it, but you just can't drive around with open cannabis in your car, and this happens a lot. You're aware of some of these cases where...
Yeah, I've got a case right now that I'm asking the Illinois Supreme Court to take to essentially define what the term reasonably accessible means in the cannabis statute, exactly what you're talking about, of where you can store the cannabis as you're transporting it from one location to another.
So you're appealing that to the Supreme Court?
Correct.
Oh, let's talk about that for a second. So an appeal is filed with the appellate court. Now, the appellate court doesn't rule in your favor. Then you move on with that same appeal to the Supreme Court, correct?
You try to. The Supreme Court, unlike the appellate court has to take every case that is before it. Whereas the Supreme Court picks and chooses the cases that it wants to take, and it takes a very, very small percentage of cases. The cases that they're really interested in is when there is a conflict among the various districts. So like we were talking about, there are 5 different districts. So the first district could hear a case with a similar set of facts and reach one conclusion. The 5th district could hear a case, similar set of facts, and reach a different conclusion. And eventually the Supreme Court will step in and say which one of those 2 is right. Sometimes they come and say that both of them are wrong, and this is the way you guys should be doing it.
That's interesting. It's very interesting. So your job can go from the appellate court to the Supreme Court, trying to get a favorable ruling for your client. Correct?
Absolutely. The fight never ends.
Absolutely. So, Omar, we got 2 minutes before we go to break. Tell everybody your website here, and as we're going to put it up here.
It's defenseadvocates.com.
defenseadvocates.com. So if you're going into the legal system, if you're a defendant, or if you got a civil case, especially like family law you mentioned, I mean, nobody wants to lose their kids, and you handle a case like that, right? Child custody?
Child custody, prenuptial agreements.
Yeah, our children are our most precious commodity. We work hard for them. We need to keep in contact with them as parents. And people fight tooth and nail in court for this. You've seen those drawn-out battles. You've read about them.
Yeah.
Omar here, Jaleel, is with us today. You want to give out your phone number real quickly?
630-360-2529.
One more time, a little slower.
630-360-2529.
And Omar Jaleel, he's defenseadvocates.com, correct?
Yep.
All right, we're going to go to commercial break in about, 1 minute, Matthew?
About 30 seconds.
30 seconds. So before we go to commercial break, Omar's going to be here with us for the second half. He's going to talk about some cases that he's handled, both as a prosecutor and as an appellate attorney. Follow me on Facebook at Pelarenos Police Project. I'm going to post this interview on my Facebook tonight, and it'll be on our YouTube at
YouTube.com at WRMN Radio.
Don't go away. Listen for the news break, and we'll be back. And if you got any questions, call in because our phone lines are wide open today.
I'm Trey Westerberg on 1410 WRMN Elgin, proudly serving the Fox River Valley. This update brought to you by Wendy's. A Kane County jury has convicted an Elgin man after prosecutors say he and 2 others kidnapped and brutally assaulted a woman they knew in 2023. State's Attorney Jamie Mossert told Fox 32 that 34-year-old Darnell Rhodes was found guilty of aggravated kidnapping inflicting great bodily harm. Prosecutors say Rhodes, along with Lloyd Hayes Jr. and Roger Heaps, kidnapped the woman between March 13th and 14th, 2023. The trio threatened her with a knife and drove her to one of their homes where they bound her with electrical cords. Prosecutors say the woman was beaten and stabbed multiple times, suffering a fractured rib, fractured fingers, stab wounds to her leg, and blunt force injuries to her head and face that left both eyes swollen shut. Yorkville police are searching for a missing 14-year-old boy who's reported as a runaway. Walter Woodcock was last seen leaving his home in the 2000 block of Overlook Court around 8:45 a.m. Wednesday. Walter is described as 5'4" and 100 pounds with blonde hair and blue eyes. He was wearing camouflage clothing with black boots and a camouflage hat. A co-conspirator in a Yorkville man's murder-for-hire plot in April pleaded guilty. Lindsay Facer of Oswego was convicted of misdemeanor criminal trespass to a residence and attempted solicitation of a murder-for-hire. Yorkville police say Facer's charges stem from her active involvement in the ongoing investigation that began in April after detectives learned that now 53-year-old Mark Hellenthal arranged with someone to have his former wife killed. Facer reportedly was not hired but had an existing relationship with Hellenthal and, quote, chose to take an active role in the plot as a result. Facer was convicted on July 29th and turned herself into the Kendall County Jail on Tuesday. A GoFundMe campaign was launched in April for Hellenthal's ex-wife and her children. I'm Trey Westerberg on 1410 WRMN Elgin, proudly serving the Fox River Valley.
Progressive's Auto Quote Explorer lets you easily compare direct rates from different insurance companies, so you can be confident you're getting the right one, even if it's not with Progressive. Way more confident than you were when you tried online gaming. Who knew 12-year-old boys could be so mean? And where did they learn to swear like that? 2 hours of losing to these underage trash talkers, and you're starting to question if maybe you really should stick to pickleball and other boomer stuff. So use Progressive's Auto Quote Explorer and be confident you're getting insurance that's right for you. Progressive Casualty Insurance Company and affiliates. Not available in all states or situations. Prices vary based on how you buy.
Now there's a new way to take charge of your blood sugar. Introducing new Garlic Healthy Blood Sugar Formula from the makers of the nation's best-selling garlic supplement. New Garlic helps maintain healthy blood sugar levels with clinically supported levels of garlic, plus a custom blend of vitamins and minerals. And it's odor-free. Take charge of your blood sugar with new Garlic Healthy Blood Sugar Formula. These statements have not been evaluated by the FDA. This product is not intended to diagnose, treat, cure, or prevent any disease. Use as directed.
This is Sarah Silver with your Fox Valley forecast. This afternoon, partly sunny with a high near 81, temperatures falling to around 79. Tonight, mostly cloudy with a low around 65. Tomorrow, a slight chance of rain showers in the morning, then a slight chance of showers and thunderstorms. Mostly sunny with a high near 82. Currently, it is 76 and mainly clear. I'm Sarah Silver on the Talk of the Town, WRMN.
Grown-ups, don't go back to school. Go forward through school into your future as an IT professional. Whether you're starting out, switching careers, or a veteran ready for change, My Computer Career can help you get into IT in just a few short months with no prior experience. So take the free career evaluation now at mycomputercareer.edu. Your rewarding career in IT awaits. That's mycomputercareer.edu. An elite CompTIA certification partner. Financial aid is available to those who qualify, including the VA benefits.
Twin Zeros at 4870 North Harlem Avenue in Harwood Heights, Illinois. Check out the full menu at twinzeros.com. Twin Zeros Restaurant in Harwood Heights not only serves traditional gyros, but also has chicken gyro sandwiches. Twin Zeros also serves a variety of sandwiches ranging from cheeseburgers and Vienna beef hot dogs that have recently been inducted into the Vienna Beef Hot Dog Hall of Fame. Italian beef, Italian sausage, and combo sandwiches. To ethnic favorites such as Slovaki and Grecian chicken. Slovaki is shish kebabs, specifically chicken or pork shish kebabs, grilled to perfection, served on a warm pita with tomatoes, onions, and our homemade tzatziki sauce. You can also enjoy barbecue ribs served every day. Twins is open 7 days a week and also delivers locally. Located at 4870 North Harlem Avenue in Harwood Heights. Check out the full menu at twinzeros.com. That's twinzeros.com.
The new novel, titled DUI Jury Trial, is the true story of two lawyers who defend a truck driver who is charged with DUI. If he's convicted, this truck driver faces a lifetime disqualification of his commercial driver's license, which would prevent him from ever driving a truck again. This 3-year legal battle culminates in a courtroom showdown, which involves the testimony of a DUI expert witness. This book, DUI Jury Trial, is now available on Amazon.com and BarnesandNoble.com.
Are you looking for a way to be creative right now? Have you ever wanted to learn to watercolor paint? You can now do that from the comfort of your own home with Zoom watercolor classes. Get professional instruction from nationally showing artist Victoria Elizabeth. These classes are step-by-step, broken down with easy-to-understand instructions. They're affordable too, at $15 for a 2-hour class. Visit her website at victoriaelizabethart.com to find out more. That's victoriaelizabethart.com.
Hey, welcome back to the second half of Life Experiences with William Pelarenos right here on WRMN 1410 AM. Broadcasting live out of downtown Elgin. Thank you for everyone for listening. As I said, if you're just joining us, I have a very, very special guest today, one of my former prosecutors who's now an attorney that handles appeals to the appellate court and to the Illinois Supreme Court. Omer Jaleel. Omer, thank you for sticking around for the second half.
My pleasure, Bill.
And I want to also mention, we were talking about this, but Omer, you also handle federal appeals too, correct?
Correct, yes. In Illinois, Indiana, Wisconsin, in the 7th Circuit.
So you handle cases in Illinois, Indiana, and Wisconsin?
Wisconsin, federally. For state cases, I practice throughout the state of Illinois.
Yes, very good. And obviously, he handles federal appeals for anybody that's charged with a federal crime in federal court. State court, it could be anywhere. It could be Kane County, right? You've done appeals for Kane County, right?
I have done Kane County appeals.
So he's done cases, Cook County, Kane County as an appellate attorney. He's also done civil cases, as we mentioned before, for cases with family law, people losing child custody battles, and similar. While we were on break, we had a question come in, and I can answer this one real quickly. The question is, can I go to prison and be deported for my first DUI? Well, they are, I know that ICE Immigration and Customs Enforcement has been scooping up people who are not naturalized or born here citizens for DUI arrest, and they have scooped them up and they have taken them into custody. And you've heard of these cases too.
Yeah, it's not something that's recent occurrence either. It's been something that's been going on for a long time.
Yeah,
if you're convicted of a
it's
crime.
just taking notice now because of all this publicity, but this has been happening for some time. Yes, the answer is they have been deporting people for criminal convictions for DUIs, and you know what else? They're harping on is domestic batteries, domestic battery cases. Because I was sitting with an immigration attorney back in January, February, and somebody had a domestic battery issue where he was either pled guilty or got convicted of, and now he was worried because he may not get his green card, and he may be deported on top of that. And it happens. You handle some immigration cases as a private attorney, right?
I have, yeah. I don't really do that anymore. But any good criminal defense attorney needs to know immigration law because it's,
It can correlate to how they do their plea bargain, or if their client needs further assistance after, in case he's convicted.
correct. And, whether to plead guilty or not is sometimes dependent on your immigration status because a criminal conviction can get you deported. It can get you excluded from the United States, denied naturalization. And so the Supreme Court has said that, the U.S. Supreme Court has said that before a defendant pleads guilty, that they are required to be aware of the potential immigration consequences.
All right, I don't want to get too deep into that. I just wanted to answer the text question. Thanks for sending that in to our caller and listener. You have some cases that you were going to talk about during the break. You wanted to mention specifically these cases that you handled. Are these cases that you handle as a prosecutor or as a defense attorney?
Well, there are cases that I've handled. Some of them are handled as a defense attorney. Some of them I've handled as a prosecutor. And they kind of run the gamut of the types of appeals that are out there, the type of issues. One case that I did out of DuPage County where an attorney was arrested and convicted of material obstruction of a police officer. And essentially what happened there was he called the police. When the police arrived at his door, he told them something that the police thought immediately knew was a lie, and he gets arrested for it. And our argument was that that's just simply not enough for a material obstruction when there was no obstruction happening whatsoever. So that goes to cases where you challenge the sufficiency of the evidence, which you're essentially saying that the evidence that the state presented against me, even if you take all the reasonable inferences from that of evidence against me, I should still be found not guilty. So those are, almost every appeal you're challenging, whether the state proved or the government in federal cases proved the elements of each offense beyond a reasonable doubt.
You know what? That's interesting. I'm glad you mentioned attorney because a lot of people, depending on your occupation, if you fall as a defendant in the legal system, there's actually a double jeopardy. Because as attorneys, if they're convicted of a crime, then they face an administrative hearing, or even if they're acquitted with the Attorney and Registration Disciplining Commission, which can suspend or revoke their legal license, correct?
Yeah, I mean, my client here had already been informed by the ARDC that if he was convicted of it, that he would lose his law license because it went to lying to a police officer.
That's your livelihood if you're a lawyer. You can't afford it. Same thing with policemen. I know several policemen over the years that have been charged with DUI. Even though they may be acquitted, the department can come back administratively and suspend them or even terminate them based on administrative charges. Firemen, the same thing. If you're convicted, if you lose your license, you can't put a bay device in a fire engine, you know what I mean, or in a squad car.
Yeah,
so
and the
people in those occupations, you really got to look for an attorney to represent your best interests, not only on the case, but down the road.
Yeah, I would say not just those, but all professionals, because just being found not guilty of an offense doesn't necessarily mean you didn't do that offense. It just means that, you're not proving your innocence. The state just failed to prove you not
beyond
guilty.
a reasonable doubt.
Exactly.
Yes. So, and that's happened. So if you're and people tell me, that's very unfair. I go, that's the way it is, because they give an example. A carpenter gets a DUI. He puts a bait device in a car. His lawyer keeps on arguing for him, and he keeps on carpeting. But as a fireman or as a policeman or as an attorney or a doctor, you don't want to lose your license or the ability to work.
Yeah. It's like a situation if, you're charged with an offense of fraud or you're accused of stealing some money or whatever it is, and you win that case because the police officers violated your Fourth Amendment and all the evidence is suppressed and the case gets dismissed. Your employer, your future employers have every right to look at the facts of the case and make a determination as to whether they want to hire you or not.
Good. Let's not spend too much time on that. Let's go some key points and cases that you want to discuss here because we're down in about 18 minutes.
Sure. Other type of issues that frequently come up, Bill, are constitutional issues. So I've handled a case that was out of Kane County dealing with the First Amendment, what the definition or whether a Facebook post amounted to an online threat, and those types of cases, are vastly different than constitutional cases, are vastly different than a sufficiency of the evidence. The research that goes into those types of cases is significantly more. The stakes of the cases are significantly higher, and the appellate courts take those cases usually a lot more seriously when a constitutional issue is involved.
You had another case, Johnson. Did you have Johnson there? What was the other
No.
case? I can't read it. You wanted to talk about?
Well, so another case I think we worked on together was when I was a prosecutor in the appellate division. I think was a case on the Fourth Amendment where a police officer, I believe you were running a drug investigation in a truck stop.
Oh no, that wasn't me. But I worked
you?
with that guy. I know that this.
Okay.
I know where you're going here.
So the basis of the stop was a Tweety bird.
He had a Tweety bird emblem on his truck or his vehicle, and he had multiple air fresheners, which we referred to in police circuits as a felony forest, because those tree air fresheners.
Yeah.
So the idea is they're using all those air fresheners to cover the scent of cannabis, and the Tweety bird is some kind of a symbol for drugs or something like that.
And that's exactly what our argument as when I was a prosecutor was, that the evidence that could seem benign to a layperson could be enough probable cause for a trained police officer. And this police officer testified that I've been running drug interdictions for 10 years, that I've been trained on this. I've seen that the purpose of the Tweety bird sticker was so they don't have to rely on a red Freightliner, which there could be 20 of them, but there may be only one with the Tweety bird sticker on it with a whole lot of air fresheners. And the police officer testified credibly that based upon his training and experience that was enough to make a search of this vehicle.
And if I remember correctly, it resulted in a conviction.
Yeah, 90 kilograms of cocaine.
Yes, but it went to the appellate court, and the appellate court overturned it, correct?
The appellate court overturned it, correct, yeah. The appellate court didn't agree that that information that the police officer was providing distinguished enough from an average person. And the issue really in that case was the police officer didn't really fully testify to why all of this stuff was significant. He kind of just said, Tweety bird's a big deal, but didn't get into why a Tweety bird sticker was a big deal and the fact that...
The foundation.
Exactly.
He should have got into his training, but you know what? Hindsight is 20/20. Yeah. But the bottom line is, and I remember when this case came down, and he was kind of talked about it. And I said, here's the bottom line. I go, the defendant had the drugs. There's no doubt about it. He hit the target on. He didn't have the correct probable cause, according to the Supreme Court. Next time, when you're behind a vehicle, stick with it until you see a violation of law. The Illinois Vehicle Code is about 280 pages thick. You can find a violation of law.
Especially on a truck.
And as an instructor at the academy, I said that. Plus another thing, we don't give their drugs back. If somebody wins a drug case, we do not give their drugs back. So they've lost their drugs. They've had to pay for an attorney. Yeah, they've got their freedom. It's a wash, but it's good to have these rulings out because if you use correctly, it adds training for the police. So now tell them, hey, besides these indicators that you know as a drug interdiction officer, look for a traffic violation. And it could be anything from a faulty tail light to improper registration. Doesn't have to be speeding or moving violation. There's so many in the Illinois Vehicle Code that you can stop somebody for and charge them.
Yeah, and the court in that case also found significant that they had been doing this investigation for 3, 4, 5 hours, and the Tweety Bird was not their target. And when their investigation was coming to an end, they focused on the Tweety Bird.
Didn't you handle another drug case where somebody went to like a convenience store? They stopped at a convenience store, and there happened to be a trooper around, and he walked around with the dog sniffing. Am I correct?
Yep. Yeah.
Tell the background of that one.
So my client is driving on the interstate highway in a rental vehicle. Rental vehicles, drug interdiction police officers find that to be a suspicious act. So he followed this vehicle. The vehicle got off the highway. He does a U-turn. He sees it at a gas station, comes up, starts making small talk with my client. He asks the client if he can search the vehicle. My client says no. My client then goes into the gas station to use the washroom, pay for gas. And in that period of time, the police officer walked his canine around the vehicle. He testified that the canine alerted onto the vehicle, into the trunk of the vehicle. And as a result of that alert, he searched the vehicle and found, I can't remember, like 100 pounds of marijuana in the front seat or something like that.
100 pounds, and he was originally convicted, and you came on as the appellate attorney, correct?
I came on after he was convicted. He foolishly went pro se at his trial, so he represented himself.
Explain to our listeners what pro se is.
Pro se is when you represent yourself at trial. So he didn't have a trial.
Didn't have a trial attorney.
He didn't have a trial attorney. He didn't have a trial attorney for the motion to suppress. He pretty much did this whole thing on his own, and obviously
he lost.
And he did a terrible job. So a lot of the reason why he lost was just he didn't bring in the right evidence into the case. And the argument that was made by us was that the police officers have a right to walk a canine around a vehicle without violating anybody's Fourth Amendment rights. The Supreme Courts have said that a free air sniff is not a search. So the Fourth Amendment is not implicated at all. But our argument was based upon a case called United States versus Jones that dealt with Fourth Amendment when there was a trespass by police officers. And our argument was based upon a case out of Idaho where this Idaho case found that a police dog search that physically intrudes onto this person's vehicle is a Fourth Amendment violation because it covers the trespass part of the Fourth Amendment.
And that was so you picked arguments not only from Illinois, you picked them up from other states.
Absolutely, yeah.
Yeah, so that shows why. First of all, there's two lessons to be learned here. The person that represents himself as a fool for a client. And you've heard that term, right?
Yeah, absolutely.
And secondly, the appellate attorney has to do a lot of backtracking. There's a lot of research. You just don't have these cases at your fingertips. You really have to do deep research. And it takes time. It's very time-consuming. There's a lot of prep work that goes into cases, whether you're a prosecutor or a defense attorney or dealing with appeals, and appeals is even more complicated.
Yeah, they're probably the most complicated of cases. Most attorneys don't want anything to do with an appeal case. there's just so many rules that are involved with it, and there's no second chance that if you mess up one of these rules, the Supreme Court or the appellate court even has every right to throw your brief out and strike it, and not even consider your arguments because you use the wrong font, or you use the wrong font size, or you've got the wrong margins on the paper, or you use the wrong color page for your front page, or whatever, all the hundreds of different rules that they have. If you don't follow them, the court can throw it out and you don't get a second chance to file it.
Yes, their template is very specific. So, just so our listeners understand, when you're working in an appeals case, sometimes the appellate court reads the brief and makes a decision, and sometimes they ask you to argue it, correct?
Correct, yeah. Most cases would be decided on the briefs. It, again, depends on the various districts. Some districts call more cases for oral argument than others, but even the ones that call cases more than the others aren't. It's a small percentage of cases. The meat and potatoes of an appeal is the appellate brief.
Say that again?
That the main part of the appellate brief or the appellate case is the brief.
The brief, the written document that you're submitting to them for your argument.
Yeah, you're not winning or losing a case based upon an oral argument, but you're winning or losing your case based upon your brief that's submitted.
But you have argued in front of the appellate court, right?
All 5 districts.
All 5 districts?
Yeah.
Wow. You've been busy these last 7 years. So this is important. You're the first appellate attorney I've had on. I'm glad you came. Because people got to understand that the process never ends with a conviction. It's just beginning if you want to win the case.
Yeah, in my eyes, after a conviction is when the fight starts. That's when true justice is going to happen, is when you fight it in the appellate court, because the trial courts are, unfortunately, there's bias, there's prejudice, even whether it's unintended. But that's not the case in the appellate court. The appellate court is more of a chess game.
All right, well, we're going on cases. You got any more you want to mention there?
Yeah, there's cases that go right up your alley of the importance of expert witnesses. So I've handled cases where this mother was charged with breaking her child's leg, and she was charged with a Class X offense. I was a second attorney on the case. When I came onto the case, the offer was 30 years, the maximum sentence on the offense. And the prior attorney had a completely different idea of how to prosecute the case. My thought was, this is a medical case, that we need expert testimony and not blaming these injuries on a third party, but directly going and having medical experts come in, look at the documents, and they made a determination that there was no child abuse, that the breaks that were diagnosed as breaks weren't in fact even breaks, and that all the symptoms that were shown were results of genetic issues and vitamin D deficiencies and other things like that. And based upon the expert reports, the state, without even going to trial, dismissed the Class X offense.
Wow. So you presented evidence where you were able to get the case. Was it reduced or just thrown out?
It was reduced to a slap on the wrist. Essentially, the
misdemeanor?
Yeah, the functional equivalent of a speeding ticket is what she got.
Okay. That's excellent defense work. It doesn't always have to go to trial. You can make your arguments to the prosecutor.
Yeah, if you bring what's going to be shown to the jury, and that evidence is just going to be so overwhelming, the state knows that they're better off not taking a case to trial.
Yeah, they don't want to waste their time or resources.
Exactly.
So anyways, one more thing. Well, an expert witness an attorney told me, I'm trying to paraphrase this, how he said it. He goes, the trial goes on a jury trial. The jurors are just sitting there. But when you bring an expert witness on, their ears perk up or something like that, correct?
Yeah, exactly. Expert witnesses are so important. They are allowed to testify to things that a lay person isn't allowed to testify to. They're allowed to give opinions on things that oftentimes lay people aren't allowed to give. So yeah, there's experts can make or break a case.
All right, we're down to 30 seconds. Thank you, Omar. You got to come back one time if you're going to trial or if you got a civil case or family law. Reach out for Omar before things don't turn out in your favor. What's your website?
DefenseAdvocates.com, and the phone number is 630-360-2529.
And anybody can call you for initial phone consultation, and there's no charge for the phone consultation, correct?
Correct. No charge for a phone consultation.
Yeah, so there's nothing wrong. The phone call's free. Reach out if you're in thing. So we got 10 seconds left. Follow me on Facebook at Pelarenos Police Project. Thank you. Be here next week. Everybody stay safe, and I'll bring another exciting guest as we go on. Thank you, Omer.
My pleasure, Bill. Thank you for having me.